Welcome to the participants. The students of the SLW646. Karibu sana to my blended class or online class, and read what I posted on the screen so that you are hearing me and hearing you. Both are sailing the same boat to reach to the destination. Read, unmute and read what I posted on the screen.
Welcome to the students of SLW 646 to the virtual class on 13th February 2023 from 9:10 p.m. to 10 p.m.
Today's topic is the International Court of Justice, and the course coordinator is Professor Dr. Mohammed Saheb Hussain, Professor of Law, South Mwanza, Tanzania, East Africa. Is it clear?
Clear, Prof.
Yes. If you happen to see our syllabus, and we have covered some of them, we did not find it, but some of them we found it, like the source of law and the evidence of stand of proof. Harmonization, we did not get it. Implementation, orders and judgment, it is also a usual process. So where we covered when we did it, when we did not make it out, and today topic is dispute settlement of civil nature, that is the International Court of Justice. So today that I would like to do the International Court of Justice, and you know where it is situated. Where it is situated? Where is this International Court of Justice situated?
Netherlands.
The Hague, Netherlands. It is only one organization which is not in the New York out of the 6. All other things are in New York. And it is the International Court of Justice, ICJ, is the principal judicial organ of the United Nations, UN. It was established in the June 1945 by the Charter of the United Nations and began work in April 1946. And the seat of the court is the Peace Palace in The Hague, Netherlands. Of the 6 principal organs of the United Nations, it is the only one not located in the New York, that is the United States of America. The court's role is to, yes, read this point I would like to see. Read this, which I highlighted on the screen.
The court's role is to settle, in accordance with the international law, legal disputes submitted to it by states and to give advisory opinions on legal questions referred to it by authorized United Nations organs and specialized agencies.
Yes, the role of this court, what? To settle in accordance with the international law. See, the word they use, the settle. Do you know what is meant by settle? They did not say adjudicate. Are you following me?
Yes, Prof.
The best judgment is settlement. I repeat, the best judgment is settlement. So they say the court's role is to settle in accordance with the international law and the legal disputes submitted to it by the states. Means International Court of Justice will not go to the states. The states will tap the door of the International Court of Justice. Is it clear?
Yes, Prof.
But in certain cases, the General Assembly gives the power to entertain the case if it is endanger the peace of the world. At that instance, it will entertain such cases. So in general, it is there. The parties will approach to the ICJ and the states, those who are the members in the UN Charter, and they give the advisory opinion and on legal issues or legal questions referred it to by the authorized United Nations organs, and a specialized agency. Not only the state will approach, but the cases were referred for the advisory opinion by the United Nations organs, including the specialized agency of the UNO, like ILO, WTO, UNICEF. These are all the specialized agencies. Now, the court is composed of the 15 judges and who are elected for the terms of office of 9 years by the United Nations General Assembly and the Security Council. So here the members are the 15 judges who are elected from the terms of the office of the 9 years. Their tenure is by the United Nations General Assembly and the Security Council, both of them. It is assisted by the registry, its administrative organ. There is a registry is there for every court, and that is an administrative organ, and its official language are English and French. I don't know whether you know it or not. Of course, let me finish it. Out of 194 member state, I believe 184, 186 got in favor of India to a judge, and who is the, if I not be mistaken, Chief Justice of the International Court of Justice. His name is, I will tell you that, Prashant Bandarek something, okay, I will tell you just. Who is elected from India to be the judge of ICJ. What his name? Yeah, I forgotten the name. See here, current members, International Court of Justice, and the person who elects the judge of the ICJ, who is the present Indian judge? Yes, it is here. Dhananjaya Chandra, no, Chief Justice of India. This is November. I am speaking about the ICJ, the judge of the ICJ. The International Court of Justice. Read. Anyone can unmute and read? Dorcas, are you
Yes,
there?
Prof. The International Court of Justice is composed of 15 judges elected to 9-year terms of office by United Nations General Assembly and Security Council. These organs vote simultaneously but separately. In order to be elected, a candidate must receive an absolute majority of the votes in both bodies.
Yes. See, and who elects the judge of the ICJ? And if you see it, the court's justices are elected by the obtaining the absolute majority of votes in both the assembly and the council, with regard to their nationality, from among the persons of the high moral character worldwide. So, General Assembly elects the judges to the International Court of Justice, and the members of the International Court of Justice would be there. But what I said is, an Indian elected and he has beaten the UK, the Britons, a big authority of the judges, who elected as Chief Justice of ICJ from India. They said, Dalveer Bhandari, his name is. Dalveer Bhandari, he is from India, and he is the member of the court since 27th April 2012, re-elected from 6 February 2018 for a term of the 9 years, and is born in 1947 in Jodhpur in India, and his education qualification: Bachelor of Humanities, Jodhpur University; Bachelor of Law, Jodhpur University; Master of Law, Northwestern University, Chicago, Illinois. The following international universities have conferred the LLD and DL honorary causa on Judge Bhandari: National Law University, Delhi; KIT University, Orissa; Tumkur University, Karnataka. They all conferred the honorary doctorate degrees to him. So he is now let me check what the news is. He is nominated as the third higher level Indo-Australian legal. No, he is elected recently. He is elected the Chief Justice of the International Court of Justice. Justice Bhandari's several hundred judgments have been reported in various important law journals. Justice Bhandari is a recipient of many national and international awards, including the prestigious Rao Sinha Award 2012. So this is Justice Bhandari is now member of the International Court of Justice, and he is elected as a, yes, yeah, here it is given, yeah, it is given. Dalveer Bhandari, International Court of Justice. Now, Dalveer Bhandari is an International Court of Justice, and he is a Dalveer Bhandari, International Court of Justice, that is World Court Judge. No thanks. World Court Judge Bhandari calls on the President Draupadi Murmu. Justice Bhandari of the International Court of Justice called on the President Draupadi Murmu of the Rashtrapati Bhavan in Delhi, and she is the President, and you can see his photo, the Bhandari's photo, and he was elected on his first trip to India after a stupendous election of which he secured the victory over the 9-year term at the International Court of Justice at The Hague. Justice Dalveer Bhandari delivered on the important messages and the link between the love and compassion of the rule of law. So he was elected, but why it is not given in the International Court of Justice? Yeah. Prime Minister Narendra Modi, he is the Prime Minister of India, credited the efforts of the External Affairs Minister Sushma Swaraj. Oh, this is old news. So he is a man from the India, and who is one of the member in the now it's the International Court of Justice in the World Court. Yes. So what I want to say is, yes, let us go to our point. How many members are there? 15 members. What is the duration? 9 years. Who will elect them? General Assembly and Security Council. Separately? Yes, separately. Secret ballot? Yes, secret ballot. All the members will elect? Yes, all the members of the states could vote it. So, including the 5 permanent members? Yes, including the 5 permanent members of the Security Council. Are you following me? Say yes.
Yes, Prof.
What are the languages
Yes, Prof.
used in the ICJ? What are the languages used in the ICJ?
English and French.
It is there on the screen. Why you are taking that much time to view? So let us see the jurisdiction. The International Court of Justice acts as a world court. The court's jurisdiction is twofold. Number one, it decides in accordance with the international law disputes of the legal nature that are submitted to it by the states. Jurisdiction in contentious cases. This is one jurisdiction. Contentious cases, in the sense those who are the member of the state will submit themselves the legal dispute to the ICJ, and it will give an advisory opinion on the legal questions at the request of the organs of the United Nations and special agencies, or one related organization authorized to make such a request advisory jurisdiction. The twofold, it is having the jurisdiction. What are they? Number one, contentious cases where the member states will submit for the disposal of the cases, the member states. This is number one. Number two, it will be act as an advisory for the legal question submitted or the requested by the organs of the United Nations or by the special agency or unrelated organization, any related organization where UNA has given a clear green signal, organization authorized to make such a request. To whom? ICJ. For what? Advisory jurisdiction. So now let us see cases. The court has a twofold role to settle in accordance with the international law legal disputes submitted by the states, that is the contentious cases, and give the advisory opinion, that is advisory procedure on legal question referred to it by the duly authorized United Nations organs and specialized agencies. So in contentious proceedings where the two states submit together, when a dispute is brought before the court by the unilateral application filed by the one state or another state, the name of the parties in the official title of the case are separated by the abbreviation versus for the Latin versus, that is the VERSUS versus. Like example which is given, can you tell me what is this EG? Can you tell me what is this EG? If you know it, you tell me. If you don't know it, you say pass on. Participants, Siokimia, your silence will kill me. Unmute and say.
Example.
Equivalent is example. English equivalent is example. But the Latin terminology is exempli gratia. Spelling EXEMPLI. Exempli space gratia. GRATIA. Is it clear?
Clear, Prof.
So that is exempli gratia. Equivalent is, for example, how do you write Cameroon? V, small v, full stop, Nigeria. They don't write United Republic of Tanzania versus, no, Tanzania versus another name they will put it there, those who submitted. So whether the two party will go to the ICJ or one party will go to the ICJ. Yes? They say unilateral application. What is meant by unilateral application?
One
Say.
party.
What is meant by unilateral application? Single party approaching there. Is it clear?
Yes, Prof.
In law of contract, there is a very classical case law is there. It is a unilateral contract. Can you tell me what is that contract case law name? If you don't know, say pass on. I will give the answer. Raymond Siokimia. Raymond disappeared. Do you know the case law name, Darkus?
Repeat the question, Prof.
What is the, in law of contract, there is a classical English case law which is said to be the unilateral contract. What is that case law? Unilateral contract. Did you understand the question first?
Yes, I understand the question, but I don't
Then-
recall that case, Prof.
Say pass on.
Pass on.
The famous case law unilateral contract means Carlyle versus Carbolic Smoke Ball Company Limited. Because Carlyle is a person who uses the carbolic smoke balls. The carbolic smoke balls company has advertised in the newspaper, whoever use these smoke balls for the 3 weeks continuously, they will be free from influenza. And they deposited some amount in the Imperial Bank, let's say about 100 pounds, to show that it is not a puff, it is the intention to create the legal relationship. So it is a unilateral contract, and the person used it, and he brought an action against the smoke ball company. So first who advertised it? Smoke ball company. Means they made forward an offer. So that is say it's a unilateral contract. Is it clear? Say yes.
Yes, Prof.
So here unilateral application means any one of the party will approach to the ICJ filed by one state against another state. Then so ICJ will call the another state to appear before it. Is it clear? At that instance, the case law name is, suppose the Cameroon went first, then Cameroon filed a case against the Nigeria regarding the international disputes are concerned. At the time, the title of the case law is Cameroon versus Nigeria. Of course, the new style of writing the case law is not underline. It is italics. Is it clear? No bold. It's the old style. Underline, old style. New style is italics. No bold. And the all in italics, including the V. Because V is a versus Latin terminology. Latin terminology should and must be in italics. So when a dispute is submitted to the court on the basis of a special agreement between the two states, the name of the parties are separated by the oblique stroke. See, when you go for the unilateral way, it is versus. But when the two states submit themselves for any dispute to the court, then the writing will be different. Between the two states, the name of the parties are separated by an oblique or a stroke or a virgule. Exemplification: Indonesia, virgule, Malaysia. Because the two parties approached together. If one party approached, unilateral. If the two party approached, bilateral. Two party approached it, then the style of the case law is stroke or oblique or slash, or Sharabaro style is virgule. Spelling Virgule. Sema. Speak.
Vacuole.
Spelling VIR. Say
VIR.
GULE. Say goat. GU. U umbrella. Goat umbrella.
TULE.
GULE, virgule. It is a Sharabaro style of saying the slash, oblique, stroke. Is it clear?
Yes.
When the two parties approach to the ICJ, then the case name is Indonesia, Virgule, Malaysia. If one party approached the ECJ, at that instance, they will call the another party to appear, but the title is Cameroon versus Nigeria. Means V is there. Here, stroke is there, virgule is there. So that is the way of representation. Did you know this type of representation of the cases? Answer is, even myself also I don't know. Is it clear?
Yes.
So the first case entered in the general list of the court is Curfew Channel, United Kingdom versus Albania, was submitted in the 22nd May 1947. And I am sure that you read this case law in public international law. Am I? Curfew Channel, United Kingdom versus Albania. So it is submitted there the 22nd May 1947, and you read this case law in the next class, and I will ask any one of you to present the case law. What is the case law? Curfew Channel, United Kingdom versus Albania. And between the 22 May 1947 and 19 January 2023, 186 cases were entered in the general list. Sir, where do you get this general list? Where do you get it? See, for instance, I will show you where you get this. If you go to the ICJ portal, yes. If you go to the ICJ portal, International Court of Justice, you can write Netherlands or need not to write. See, this is the portal, International Court of Justice. And in this portal, you could see this is the building and the palace, and there it is situated in the Netherlands, Hague. And see the registry, cases, list of the cases. Did you see it here? And list of all cases. See, 2022, 2021, 2020, and if you go on like that, you could see the Curfew Channel 1947 case law also. See, 2001, these are all the cases, all continuous cases, because two parties approached them, either unilaterally or bilaterally, anyway. And here, advisory, this is. But the most of the cases are contentious, means contested one. Means one party approached it, another party want to defend it. So if you scroll it, and you will find all the cases of here. So we say, here is, did you see Curfew Channel case law, 1947, contentious. It is 1948 it is made, and condition admissible of state membership, advisory this is. So 1947, and it is ended by the 1949, the case law. You could get this case law from here. If you just click it, and you will find the case law. See, the Curfew Channel, United Kingdom, Britain, and Northern Ireland versus Albania. The dispute gave rise to the three judgments by the court. It arose out of the explosion of mines by which some British warships suffered damage while passing through the Curfew Channel in 1946 in a part of the Albanian waters which had been previously swept. The ships were severely damaged and members of the crew were killed. The United Kingdom seized the court of the dispute by the application filed in the 22nd May 1947 and accused the Albania of having laid or allowed the third state to lay the mines after mine clearing the operational had been carried out by the Allied Naval Authority. I don't know whether you know it. What is meant by mine? M-I-N-E-S, mines. It is explosive material. If any, it is implanted either in the water or below the water or on the surface of the earth. If anybody tread on it, keep the leg on it, he will become a pamba, cotton, such a high explosives. So such explosives, they kept it by third party in the Corfu channel. By that time, the UK ships are passing over there, but the water is Albanian water there, and hence the mine clearing the operations had been carried out by the Allied Naval authorities. The case had previously been brought before the United Nations in consequence of the recommendation by the Security Council had been referred to the court. Because sometimes the people will keep the mines in the high seas either to capture some ships or not to allow the ships to pass through that channel. They will make it out by any means. So in the first judgment rendered in 25th March 1948, the court dealt with the question of its jurisdiction and admissibility of the application, which Albania had raised. The court found inter alia that a communication date 2nd July 1947 addressed to it by the government of Albania constituted a voluntary acceptance of jurisdiction, because it is also a member of the United Nations Charter. It recalled on that what occasion that the consent of the parties to the exercise of the jurisdiction was not subject to any particular condition of the form, and stated that at that juncture it could not behold the irregular of proceeding not precluded by any provisions in those texts. So if you see that it is in the third, it is finally what they did. The court did not accept the first of this complaint, but found that United Kingdom had exercised the right of innocent passage through the international straits. On the other hand, it found that the mine sweeping had violated the Albanian sovereignty because it had been carried out against the will of the Albanian government. And in particular, it did not accept the notion of the self-help asserted by the United Kingdom to justify its intervention. In the third judgment rendered by the 15th December 1949, the court assessed the amount of the reparation owed to the United Kingdom, ordered the Albania to the pay. The question is there, why do you keep such an explosive mines in the Albanian water? Is it not a dangerous? Answer is, it's a dangerous. And these UK ships, they want to clear the mines, sweep away the mines, which are clearing it, because it is a passage where the ships will pass on. When it's a pass on over there, no doubt a sovereignty would be there on the state to keep, but not the dangerous things which will be used by the other people also. Can you keep the mine in your own house not to allow to make threat or to self-protection of your property? Dorcas,
No.
when you keep such a thing in your house, you have to keep a caution board. Like we have the case law, Tulip Garden case law. He put the spring guns over there, but he did not keep the caution board, and hence the owner is held liable to pay the compensation because adjacent man has entered into the tulip garden for the catching of the fowl, that is a cuckoo, and he passed from the tulip garden, and where he caught by this spring gun, and he was injured, and his leg was trapped by the spring gun, and he filed a case against the owner, but the owner said, "You are a trespasser." Yes, I am a trespasser, but I came to find my cuckoo. Najua. Fowl means a board, F-O-W-L, fowl, and you have to keep the caution board over there, but you did not keep the caution board, hence you are the negligence on the part of it. In the same manner, any sovereign country should have to keep the cautions. It is the water of the Albanian water, hence nobody should have to enter. I don't know whether you saw that viral in the WhatsApp. Chinese balloon went into the area of the USA for spying. I repeat, Chinese balloon went into the that is called restricted area of the for spying purpose. So the two jets of the United States, they tried level best and they blown the balloon. Have you seen? It is viral in the WhatsApp. Give me the answer whether you have seen or not seen.
I did not see, Prof.
Yeah, it is. If I find no, I will forward to you. The reason is no one can allow to enter into the water of the Albania. When Albanians kept the mines in their own land in the sea, but they have to give the caution. Trespassers, be aware, mines are implanted. Don't enter in your premises. So, nobody will enter into the premises. If you want to protect your own water, the sovereignty would be there for the state. Because ocean, are you the owner of the entire ocean? Like Tanzania, Indian Ocean is there. How much you have the fishing rights? There is a rule is there. You cannot go beyond the fishing, that area. Sometimes they say continental shelf, sometimes they say 3 nautical miles. You can fish it. But other area is said to be the high seas. In high seas, you are not supposed to do any other activity. Except if you want to pass, you can pass from the high seas. Is it clear?
Yes, Prof.
Can you fish in the Lake Victoria? I don't
Yes, we
think that
can.
everybody can go and fish in their Lake Victoria. Okay, for merely keeping the stick, okay, you can fish it, no matter. How many kilos that you fish with the stick? Only 1 or 2 or 3 or 4 or 5, but not 1 ton. Am I right?
You are right, Prof.
So those who are fishing the daga, they do have the license to fish. Answer is yes. Because they purchase the license. I mean, they will license it and they will, and that to be the rule is there. You should not take the daga of so and so size or so and so thing. Even a talapia or nail perch, they do say that small things should not be caught out of there. A particular size should be caught out of there. But now I could see that either a small, even a sato is there, a big sato also there in the market. So there is a condition is there, and that condition should be fulfilled over there. Then only that you will be given the order to fish, and that to be in certain area that would be there, and there we can make it. So what I want to say is, every country is a sovereign country. In a one sovereign country, another country could not encroach on it. Is it clear?
Yes, Prof.
So here they said the third judgment they made rendered on the 15th December 1949, the court assessed the amount of the reparation and owed to the United Kingdom and ordered the Albania to the pay this is pounds 844. 1/10, 100,000, 10,000 lakh. I don't know how do you say 8,44,000 pounds they have to pay the reparations because they did not inform that there would be the mines, and these mines they are clearing it, or they are passing by, they damage the ship. So that is the curfew water channel case law, and there are so many cases are there such a nature where continental shelves case law also there, and with this we can make it out all the cases which are very important. At least in the examination point of view, I may ask her at least one or two cases in this nature which are very important. Like today I discussed the curfew channel case. And then if you just happen to go it, you will find the important landmark cases also. Like that we can say the product person Egypt, France versus Egypt. There is a continuous case law. It is also. And asylum, Colombia versus Peru. It is also a continuous and a landmark case law. And then we can say the Colombia versus Peru. This is another case law. Is there any case law between Tanzania and another country? Yes?
I have no idea, Prof.
Even myself also. But India is there. India is there. Yes. To my knowledge, just you can type it in the Google search engine and you will understand International Court cases of India or Tanzania. If you type it, perhaps you could get some of the cases where it is really the case is there or not. So each one cases are there, and that goes to the ICJ and divide it. But let me see the latest case. What is the latest case should be there in all cases? 2022 dispute over the status and use of the waters in Silala versus Child versus Bolivia. Child versus Bolivia. This is the regarding the waters is concerned, and that case law is dealt here. Oh, so many. Record, verbatism, record. So full case law is application of the instituted dispute of the state and use of the water of the Silala versus Child Bolivia. Cases, previous cases, next case, and what is the English? Yes, it is English. See, International Court of Justice application, the instituting the proceedings filed by the registry of the court, dispute over the status and the use of the water of the Silala, that is a child versus Chile or Chile. Chile versus